Okay, so as part of our FTO program, we need you to understand what your authority as a peace officer is and what your authority to arrest is. And this is really what makes us special. This is what makes being a law enforcement officer different than being. This is why you go get your certification as a basic law enforcement officer. So you should know, or at least heard of it before, that citizens can make arrests too. Okay, so if a citizens can make an arrest, then why do we need to be certified as law enforcement officers, and why are we special compared to them? So if you look at 17-4-60, you'll see that this statute covers citizens' arrests. But what you're going to see here is that citizens can only make arrests if the crime happens in their presence, is also a felony, and that that person is attempting to escape. It also, going on in the 17-461, it says that they have to take the person to a judicial peace officer, et cetera, et cetera. So, just continuing on with that, if a citizen can make an arrest, why do we need our certifications? Why do we need our training? Why have us at all? If we could just hire, the county could just hire some people to go around and change tires and help the community, and just let citizens make their own arrests. Well, it goes into us having more authority to do things. We don't necessarily have to have the crime committed in our presence. We can arrest for things other than felonies. We can stop people and investigate crimes. A citizen cannot stop someone and investigate a crime. So, looking at some of our statutes, we're covered by 17-4-20, along with some others, but this one covers a peace officer making an arrest without a warrant. In that code section states that the officer may arrest someone if they have probable cause to believe they have committed a crime. Generally, the statute reads that you must have a direct knowledge of that crime to make an arrest without a warrant, along with some other things. An easy way to explain cases where you can make an arrest without a warrant is, to begin with, is if the crime happens in your presence, we know we don't need a warrant for that. But let's take another case. We'll use shoplifting, for example. If you're responding to a local Dollar General and for a shoplifting case, the clerk has called and said that a subject in the store has stolen several items, and you arrive on scene and you find that subject, the clerk points them out as the person they called about, and you question them and say they have some items in their pockets. You didn't witness the crime, you didn't witness the taking of the items yourself, but you have a little more direct knowledge of this. You were here immediately after the crime. The person still has their property on them. So it's a little bit of exigency when it comes to arresting without a warrant. So on the flip side of this, if you're investigating, say, a stolen lawnmower case where someone has stolen someone's riding lawnmower from their home, you investigate this for a few days or a week, and then you finally locate it and you want to arrest the person who stole the lawnmower. Well, typically in this case, you're going to need to go get a warrant. There's not a lot of exigency here. You can seize the lawnmower as evidence if you need to, and obviously you can return it to the owner. But there's not a lot of exigency. Whereas with the shoplifting case, you're there on scene, you found the person, it's just now happened. If you were to let this person go while you went to try to get a warrant to arrest him, he could disappear, he could flee, you may have issues getting him to return to court, etc., etc. Now, you still have to remember that you have to get a warrant within 48 hours of making the arrest. It's not 48 to 72 hours. Don't confuse that. You must get the warrant within 48 hours. The judge themselves have up to 72 hours to see the person for their to issue them a bond, to decide if they're going to issue them a bond. So moving on into that, 17-4-40 covers the issuance of arrest warrants. Now, this typically goes by a written affidavit that you will take to the on-call magistrate judge. Now, most of the time we just use our incident reports for this. You can just print out a copy of your incident report, take this to the judge. give them your verbal affidavit. So an affidavit is just a statement. It is an easy way to look at it is just a truthful and oathful statement. A statement under oath is an easy way to look at that. So you can give the judge your statement or affidavit, and they'll decide that if the person you want to take a warrant on, they'll decide if they need to issue a warrant against that person. If they're already under arrest, you'll just turn that warrant to the jail. If they're not under arrest, you will return that warrant to our warrants division, and they can file it away. If the person lives in another county, they can also send a copy of that warrant to the county in which that person lives. So most of our cases fall under a magistrate judge. So any duly appointed or elected magistrate can issue a warrant. In some cases, a superior court judge needs to write a warrant. This is typically for elected officials and other peace officers. There's a few other outliers as well. But for example, if you ever arrest another peace officer, you'll need to go see a superior court judge for that. Now, one other little case law that I'll point out to you when it just comes to warrants, this is a little off topic, but 17-4-60 covers your rights to break a door. We do not want you just kicking in doors all the time, but I do want you to understand when and when you can't do it. So say you have a valid arrest warrant issued by a magistrate judge, and you want to go serve this warrant. So you go to a home, you knock on the door, and say a mother answers the door, and you ask if your wanted person is there, and she says no. Well, while you're talking to her, you see that wanted person sitting on the couch behind her, but she says no, he's not here, and he shuts the door in your face. Now you know the person is there, you have a warrant for his arrest, and they're not allowing you entry. I would suggest trying to knock, give good verbal commands through the door. Hey, you need to step out. You need to come out. This is the Lawrence County Sheriff's Office. We have an arrest warrant. Whatever, funny stuff you want to tell them. But at the end of the day, if they don't let you inside of the home to effect that arrest with that valid warrant, you do have the right to kick in the door to go make that arrest. So just cover that a little bit, and you can read it a little more. So moving on from there, so a few case laws we're going to talk about here. This is Terry v. Ohio, Miranda v. Arizona, and Tennessee v. Garner. You'll hear about Tennessee v. Garner later in our use of force, but I'm going to detail it here just a little bit. But we'll begin with Terry versus Ohio. They definitely would have talked to you about this during mandate, but we're going to cover it again. This covers our stop and frisk or our investigative stops. So Terry v. Ohio basically states if you have articulable, reasonable suspicion that a person has committed a crime. So we don't have probable cause that they've committed it. We don't have proof beyond a reasonable doubt that they've committed it. We just have more than a gut feeling based on the knowledge we have as peace officers that they have committed a crime. You can stop that person and you can investigate to determine if that crime actually happened. This can be a person on the street. This can be a vehicle stop. So it's just an investigative stop. The person is not free to leave until you've concluded your investigation, but they're also not under arrest. So this could be something like with a say you have a burglary happen nearby. You're responding to a burglary call. Maybe the homeowner tells you a white male with long blonde hair wearing a black beanie in a red hoodie and blue jeans burglarized my home. I saw him run out the back door. You answer the call, you do your report, take your notes, and you're leaving, and you see a person, a white male with a black beanie and the hoodie and the blue jeans. Now, you won't know for sure that this person is the one who committed the burglary, but he likely did it. I think any reasonable peace officer would believe, yeah, he was right here in the vicinity, matches the description. I think he did it. We need to stop and investigate him. So based on Terry v. Ohio, you're allowed to do that. You can stop that person to investigate. Now, let's say we're still dealing with that same subject. You find out that it is him, or you have probable cause to believe that it's him. So you make the arrest. You make a warrantless arrest. But you want to continue asking him questions post-arrest. So you've already made the arrest. You need to remember Miranda v. Arizona. This is the fancy TV stuff. You have the right to remain silent. Anything you do or say can will be used against you, etc., etc. It's important to remember that you only have to read them this if you're going to ask them questions that you're going to use for your case. Now, if you arrest him, put him in the back of your car, and you just ask him, "How's your day going?" That is a question, but if it's not relevant to the case and you don't plan on using it in court, he doesn't have to necessarily be Mirandized for that. But if you do place him in handcuffs and place him under arrest, and you ask him, "Hey, where's the property at that you just stole from that house?" and he tells you, that property is in this wooded area behind the home. I hid it there so I can go back later and get it. Well, everything that you just asked him is now what we call fruits of the poisonous tree. You got it illegally. He was not Mirandized. He did not know that he had the right to remain silent and that he had the right to an attorney, etc. Also, what you may have just done there is that even the property, if you were to go find the property, now you may not even be able to use that as evidence unless you can show that you would have found it anyway. I'm not going to go too deep into that, but just to point out that if there's an inevitable discovery rule, okay, so if you want to research that, inevitable discovery, it's just that even if you obtained the information illegally, had you, um, if you can show that you would have found it legally anyway, then you can still use it. But we're not going to go too far into that. Just remember that if you ask them questions without reading their rights post arrest, that you're not going to be using any answers or information that you gathered from that conversation. Okay, that's going to be fruits of the poisonous tree. Now, when we talk about arrests, we'll talk about use of force a little bit. Your FTO is going to cover use of force laws and things with you later. But one of those is Tennessee v. Garner. Another one is Graham v. Connor. We'll talk about more of these, or both of these, more in depth later. But Tennessee v. Garner just covers using force against a fleeing felon. So you have to remember that any type of force against a person is also considered a seizure, and seizures are generally considered arrests in most cases. So just remember your laws against, or your laws that govern use of force cases. Try to keep those in mind when you're using force. So some key outlines for how to make an arrest. You need to identify yourself. I'm Sergeant Edge with the Lawrence County Sheriff's Office. Then state your reason for the arrest. You arrest for burglary. I have an arrest warrant here if you want to show it to them, etc. Make sure you keep saying your FTO is going to cover safety protocols with you later. Use we'll also cover use of force later. Read them their Miranda rights if you have to. If you don't plan on asking them any questions, it's not TV. You internet. People say time to time, oh, this deputy, this officer, this trooper, he didn't read me my Miranda rights, so he messed up. If they didn't ask him any questions, they didn't have to read those Miranda rights. Transport them into the jail, turn them over to the jail staff, and then complete any and all documentation that you need to complete. So overall, these are the things that make us special. If you want to feel special, these are the things that make us special as law enforcement officers. We can make arrests, we can investigate crimes, we can stop people without even knowing that they committed a crime. We can stop them just to investigate if they committed a crime, so long as we have that articulable, reasonable suspicion. So we're going to move on from here later in our lesson plans. If you have any questions, reach out to your FTO. He'll be happy to discuss any of these statutes or case laws with you. I'm usually typically here as well. If you need any help from me, we'll just reach out. Just want to wish you good luck through our program. I hope it's great for you, and I will see you next time.